verbiage in blue that says that are used in their child's classrooms, that was not present before, right?
Correct. That was not in the NCSBA version. That's another example where our edits are just to more closely track SB 49. So the NCSBA model policy would allow parents to inspect any instructional materials used in the school or anywhere. And they had it all in a strict 10-day timeline. So in theory, that could mean a parent requesting to see all instructional materials in the entire school district within 10 days, which obviously would be impossible to fulfill. Now, I will say that most instructional materials are public records, and so anyone, not just parents, would have a right to inspect them, but the timeline for public records requests is a more flexible, as promptly as possible timeline that depends on the scope of the request. So here we wanted to avoid the strict 10-day timeline applying and also limit these edits to what's required by SB 49.
Yes, I just have a question. I'm just wondering, why did we remove this part where it says Board Policy 4720 when it comes to surveys? Why was that removed from the paragraph? In paragraph A?
That was a recommendation by the School Board Association.
Yeah, that was their edit.
That's their edit. We're also bringing 4720 to you today to show you the revisions required by SB 49 in the Surveys for Students policy.
Yeah, I think I can understand why NCSBA did this. So it used to be under the Parent Protection of Pupil Rights Amendment of federal law that there was a requirement to allow inspection of materials used in connection with certain surveys. SB 49 goes beyond that and says parents have a right to inspect all instructional materials used in their children's classroom. Doesn't matter if it's connected to a survey. So we're really kind of just making sure that this complies with SB 49.
So I guess just to reiterate, the reasoning behind taking out 4720 in that paragraph is because we're just blanketly saying all
instructional materials used in your child's classroom, regardless of whether it's
surveys.
Correct.
Yeah. Okay.
And there's a separate rule in SB 49 on surveys too, but that's not addressed in this policy. It's a separate policy.
But it will come back to us later in another policy.
Yeah, that addresses my question.
Okay, perfect, thanks.
Actually, it's on our agenda for
Yeah,
today.
yes.
4720 will be there soon.
Yeah, I was about to say, I think it's in 47.
Yes.
It is. I just wanted to make sure that it wasn't like one policy says one thing that they aren't. Sometimes it's better when they're tied together or you have the links between the two, but if it is saying that it's all instruction material.
And 4720 does not, so that's why we're reiterating that this policy is different than 4720.
Right.
It's all material,
Yeah.
because that's what's in Bill 49 says. Any other questions, comments, feedback?
So I'll recommend we move this to first reading.
Second.
Mr. Hagerty, Mr. Swanson. All in favor, please note by saying aye.
Aye.
Any opposed, same sign. Hearing none, the motion passes. Thank you.
Our next policy we're bringing to you is policy 4335, reporting criminal behavior. This policy details 10 acts that must be reported immediately to law enforcement when principals have knowledge that they have occurred on school property. Those are listed in the second paragraph. You'll see in the third paragraph that we added guardian a couple of times in blue to reflect the inclusive language that the board has asked us to include in policies sort of leading up to this place. So anytime we have a chance to go back and add that, we try to do that. In the fifth paragraph, the North Carolina School Board Association recommended a revision describing the requirement that if a school system employee suspects the child has been a victim of any criminal act, regardless of where the act occurred, it must be reported to the child's parent or guardian. This includes that list of 10 acts above in the second paragraph, but is not limited to those. An exception is provided if the incident has been reported already to law enforcement or county child services, and reporting to the parent would compromise that investigation. The legal references have also been revised. All of these revisions can be seen in red. You see our addition of guardians in several places in blue. These revisions do require a change to our current operation. Staff are working on new procedures to share with building administrators on how such reporting should happen to parents.
And except for the addition of the word guardian to clarify legal guardian as a parent, all of this is strictly required by SB 49, so there's not really a lot of discretion in this language. It's all verbatim from the statute. Excuse me.
Do we use the word promptly at times. Do we have a standard definition of what that means?
So that's the statutory phrase, and I don't think there's a standard legal definition for the word. So
We do include in the paragraph, in the bottom of that fifth paragraph, such notice must occur by the end of the
Oh,
workday
thank you.
in which the incident occurs. That's for those 10 acts, when reasonably possible, but not later than the end of the following workday.
So that's from your policy.
Yeah, that's our policy.
That's not state law, but I think that's a reasonable, helps flesh out what promptly means in this context. Okay.
Anyone else? As always, thank you for adding guardian, and for clarifying that there will certainly have to be built-in RMP on the actual implementation of
Yeah.
what will feel like a broad sweeping change to them, because it was limited to just 10X, so this will be a significant change for staff and educators in buildings. Okay, hearing none, I'll entertain a motion.
I move that we move it to first reading 4335.
Second.
Ms. Evans and Mr. Swenson? All in favor, please know by saying aye.
Aye.
Any opposed, same sign. Motion passes.
That's a good point about distinguishing it, any offense from
It
the
will
10.
be. Process will be. Or-
Next one.
Yes.
Our next policy we're bringing to you is surveys of students. As we said earlier, this is coming along behind 3210. This policy describes how we meet the federal and state statutory requirements for surveying students. School Board Association recommended multiple revisions throughout the policy within the context of SB 49. In general, the revisions detail specific requirements for protecting student privacy, notifying parents, and obtaining consent. Many of the revisions are organizational, so you'll see new headers and numbers to reorganize the policy. These revisions, though numerous, do not currently significantly change our current operations. Staff's developing guidance to ensure everyone is knowledgeable of and adhering to all of the specific requirements regarding notification.
Ms. Evans?
So with these revisions do not significantly change our current operations, can you point to places where it does or may?
I can just share that, for maybe help to sort of frame this, the basic change that SB 49 required in the policy here is that protected information surveys, which are surveys that address certain topics like the religious beliefs or political affiliation, sensitive subjects. It used to be that you could have a parental opt-out for some of those surveys, and SB 49 says it's all opt-in, prior consent required in all cases. So even though there's a lot of red here, as Julie said, it's mostly restructuring and aligning with the NCSB language. That's the bottom line rule. Protected information surveys require advanced
Is
parental
the
consent.
opt-in?
Opt-in only, it's no opt-out option, but I think to Julie's point, it's not going to impact district operations much. Others can speak to it better than I do, but my understanding is you generally do use an opt-in approach, even though the law allows opt-out for protected information surveys. So for example, correct me if I'm wrong, the Youth Risk Behavior Survey has been an opt-in, correct?
Yes.
And so the law would allow, and now that's been carved out of the statute, so that is something that you could think about. You could, if you want, that's a change in the budget bill. The Youth Risk Behavior Survey and the National Tobacco Survey are the only two surveys for protected information. The General Assembly has said you can do an opt-in, but staff have told me for some time it's been an opt-in approach in your district anyway. So as long as you stick with opt-in, you're changing what the policy requires to track the legal requirements, but not changing practice. Is that fair? Thank you.
I have a bit of questions, so I'm sorry. We're saying opt-in, and almost as if like the whole policy 4720 is opt-in, but I see a lot of strikeouts where, like, say for example, in A1, it says the school system must obtain prior written consent of a parent or eligibility student before the student is required to participate, and we crossed all of that out. We also crossed it out on section 2A. So we crossed it out there. So if the transparency of having the parents opt in is the option, why are we crossing out that language?
I think it's been included down in 2B, which
Yep.
is notification, and 2C,
Right.
which is consent.
It's just a restructuring. So you're right, there's a cross out there, but that's because the section 1A is now just definitions. And the parental consent has, to align with the NCSBA policy structure, has been moved to section 2B on the second page there. So it does say all questions on these topics require advanced parental consent. It's just a separate section on consent.
Okay. Admittedly, when I read through the policy changes with all the strikeouts and everything,
Yeah.
I literally had to sit there and read out loud to make sure that it was making sense. And then I printed it out because there is a lot of movement in this policy here. So just a little, I guess, confusing.
Yeah, restructuring is confusing to your point.
Yeah, but I mean, it's basically, we've got 4 pages of verbiage here, moving something from here to there, and so before we do first read, it might be easier to just see it how it's not attached here, right?
To see it how.
Just to see how
Without
it
the
would
strike
look.
through.
A clean copy, not a red line copy?
Yeah, just to,
Yeah, we can get a clean copy.
I think it's in the assembly. Is it not?
I don't think so. I
No,
think
it's
we
just,
had
it's
our
the
prior
preview,
and
it's the actual
strikeout.
version now. Yeah, it's not a clean
Yeah,
copy.
the current and the markup.
Yeah.
Oh, I see, that's correct.
And on section B, the parent notification, that I would think would be more where it's very clear that the parents are able to view the content. I'm not sure the verbiage says it that way.
Well, it says they have to see it at least 10 days in advance. Say more about what you,
The policy tracks
Would like
the
to-
law, which now requires at least 10 days before the survey is administered, the parents have to receive an actual copy and have to actually give their affirmative consent.
Well, it says we'll provide the opportunity to view both electronically. How do we provide it to the parents for transparency purposes?
Normally we post it on our website and make it a public link, and then we'll send a message to parents through the school with the link that they can access. And then for parents who don't or can't access it that way, we'll make paper copies available in the school. They can come in and review if they want. So it's either available online or it's available in hard copy at the school.
So they'd have to either go to the school to see if there's something they're missing, or they would have to go on the website to see if there's something
They
they're
would
missing.
have to click on the link and the message that goes to the parents in order to review it. Yes. Those are the two ways we can release it. When that does come up, which is
So for me, in my opinion, I think for us to have complete transparency on that, I mean, we get 1 million pages that come from our students, and they come home on like the first week of school, and you have to sign all these things away. That, to me, would be more transparent, that parents would have to sign that they're opting in or opting out versus going and seeking this information for notification.
for standard surveys, I hear you on that, but not all of the surveys, except for the 2 that we mentioned, right? Like, there could be a survey that's not known the first day of school, which is why there's a timeline that you have to review it. So
So how would we know,
I'm
right?
looking at Dr. McMillan.
Yeah, I think the challenge for us is more things that happen in an individual school rather than things that come through the district, because to Dr. Neal's point, things like the youth risk behavior survey, the youth tobacco survey, those are on an every other year schedule. We know years in advance when those are coming, so that's a very easy thing to include in like a welcoming packet for parents. I think the thing we have to be careful to be vigilant about is the thing that happens at only one school that doesn't necessarily come from the district, but might come from, a federal government research agency or a think tank from, up in DC or something like that, and make sure we're educating sometimes those will come to them unsolicited and don't.
That to me seems like there's a lot of room for error there, right? I mean, if we can't even get, at the boardroom with our policy, we can't even get like, here's our go-to spot. How a parent's supposed to know, oh, another survey popped up. Maybe I should go check out the website. There's no way for them to read it. Do you understand what I'm saying? Like, doesn't seem very transparent and like, here's the information here for you if you want to view it.
What's your recommendation?
Give me a minute to look at it more.
Will do.
Now that I have that
Mr.
answer,
Hagerty?
give me
I
a minute.
mean, to me, if all of these surveys are going to require an opt-in, all parents will have to receive an opt-in form
Every survey.
every survey, so wouldn't the opt-in form just tell them where to find it?
Yeah, I think that's what
That's
Brad
what
was
he's
saying, is the
saying.
general idea. The notice
Yeah.
goes to the parents, there will be a survey in 20 days from now. You can inspect the materials here to opt into the survey, click here. And without the consent, which that same notice would tell them how to find it.
Yeah.
And then they have at least 10 days to review it before they make up their mind, and only if you get the consent.
So it's part of that review before they even, give their consent, so, okay. I have other questions, but they're on other parts of this, so
Okay.
if we want to go to someone else, or if you want to talk about this, or I can
That's a
ask
good
about another
question.
part
Is
of the
yours
bill.
about the same thing?
I wanted to respond to Cheryl,
Okay.
just in that, so if the parent doesn't see it and review it and doesn't give consent, the kid doesn't see it.
They would never get the
The
survey.
student doesn't see it,
Okay.
because it's required that they have to consent.
So if you hide it in 20 sheets, that kid doesn't take that survey.
Okay.
I mean, I understand what you're saying about the parent having the opportunity to see it first, but if they don't see it, if they miss it, and they don't opt in, the kid's not gonna see it.
That's why I was asking what
Yeah.
you'd like to, like, what else would be clear?
Yeah, and I knew that there was different surveys that Wake County sends versus the school and teachers do. So there's different layers.
Yeah.
And I just feel that it gets lots of digging for information for a parent to even know that it exists, to even opt out. So so you're saying that teachers, staff, and principals have to go through the opt-in option. So they need to go somewhere to say, opt my kid in for this.
They have to sign.
Yeah, okay.
Information.
That is only on protected topic surveys.
Right.
So the topic's listed in this,
Right,
in
the
this
topic's
policy.
listed.
Not
This-
any survey. You can collect basic demographic data, et cetera. You don't necessarily need written parental consent to ask a student any question. But
You
if
still
you're
ask
asking
the
about
student to
political or
eat for
religious
apples or oranges.
affiliations or psychological problems, you do need.
Right, and it's in the second paragraph up top says
The list.
that the definition of the survey does not include pedagogically appropriate activities that might encourage students to consider or reflect on information related, that so that it does not require students to disclose information. So it doesn't, this is not about those kinds of surveys. This is about asking students on these protected topics.
And to clarify, it keeps us closely aligned to Senate Bill 49. Literally.
The good news is that the categories are not new.
Right, that's
The
what I was-
PRA has been
that's
in
what I was
place for
reiterating.
At least 30 years, I think. So,
Yep.
so really all you're doing is saying there's no opt-out option, it's all opt-in.
So I guess that part isn't so clear to me up top. And my thinking is, we've gotten some emails from teachers and staff that are confused in how are they supposed to apply this policy in their classroom. And they're confused, I'm confused, then we might not have specific language
Well, they were
saying
confused because
it.
we didn't have a policy.
Right.
So they were saying, hurry up and tell me the policy. Because they knew that we had opt-out before. So their email was legitimate, right? We had not talked about Senate Bill 49. So I guess what let me ask you this. Are you recommending, and you tell me if this is what I hear you, because I could be wrong. It sounds like you're asking us to describe what opt-in is explicitly.
I was gonna say, if we
Is that-
can be specific on instruction of what opt-in means and how to do that, before we break down into all this terminology of what we're gonna do. So that it's just specific, look, it's opt-in, this is how you do it, this is where you go, and then here's all the definitions that pertain to the information. I think it would be more clear.
Would
Does that
be
make
in the
sense?
RMP?
So I was gonna look to Neil and Julie to ask if we could put that in RMP. I would dare to say for you, I think parents might not know what opt-in and opt-out is. Our educators do. They were really saying, just tell us what we have to do. But I'll look to you to see if that's something Brad, that you think we should put in RMP.
certainly doesn't hurt. I mean, more information is always better than
Sorry,
less.
Dr. McMillan.
Yeah, I don't see any harm in doing that, just being clear about what that looks like. But to your point, educators are used to that. We have to do opt-in for things like field trips and all
Yep.
kinds of other stuff, and so they're very used to that same.
Yeah, they do know. And I would also go on a limb and say, so do parents, since they've come and asked us to change it. But that's why I'm asking you what you're asking. Like, what's your request to staff and to this committee?
I think in the beginning of it, I would like for our policy to explain what our options are as far as, or instructions are as far as opt-in and how it pertains to the policy, like the steps that would be followed. I don't really have specific language because I'm understanding it as we unfold.
Well, the language is in the section that you brought us to, which is the parental notification is a step.
And so,
Yes, sorry.
Sections 2B and 2C
Yep.
require, I guess, if you're asking what are the mechanics for obtaining consent, that's not addressed in the policy. I think probably because, as Brad pointed out, there are district-wide surveys that are annual or biannual, and you certainly have a process for that, but there can also be other smaller surveys administered at the school, and there may be a different consent process, but what the legal requirement is a written consent. So you do need a parent's signature on a form or something before you can administer the survey.
And it's also explicit for K3 in section B. Dr. Eno, I wasn't sure if you were going to add on to this before we, or should we finish this?
I am, yeah.
Okay, go ahead.
Yeah. I was just thinking, in terms of being, for Ms. Caulfield's desire to be more clear, to add a sentence under B, section A, 2B, parental notification, whether we should just say like a first sentence, this is in alignment with new, or whatever, how you language it, but in alignment with such and such, this is.
I mean, we probably can say this, it'll have a session law, so we wouldn't be calling it Senate Bill 49, we'd be actually saying this is in
General
alignment to
statute.
state policy.
Yeah.
Is that where you're
Yeah,
going?
or in alignment with, and then saying that this is following it. Do you want to say opt-in as a terminology?
Well,
I
So
don't know.
that was one of my questions on that. Like, I understand that people might not know what opt-in means, but the policy doesn't use
I know.
the term opt-in.
It's not the
And so it was
statute.
like,
It's not in the statute.
yeah, so we could come up with a section of the policy that defines it, but we're not using it. Instead, we just define what notification is and what consent are, and those would be what we would use to define the term opt-in. So I sort of had that same thought about, do we need a definition? But then as I looked at where we would put it,
Yeah.
it sort of seems that it is already explained in the policy, and that if we create a term that's not used in the policy and then define that, we might be confusing
And also
more
not defined in
people.
statute.
But back to the earlier idea, we have references in some other policies that point back to a session law or general statute. And I think for clarification, we could add that here if you wanted. Just say in accordance with North Carolina general statute, whatever it's codified at, and then have the rest of it. And then that would give people that legal citation too.
I think that's a good kind of, reference in there. I mean, of course, I think the RMP will be most important to kind of, clarify to
implementation.
everyone, right?
Yeah, I think that's actually good because it gives it more of like instruction and definition. You know what I'm saying?
Well, yes, if
Kind of-
people go pull the law, yeah. I would
Right,
agree.
because then if it has the link on there, then they're able to go in and see exactly what does this mean for me as a parent or guardian.
Mr. Swanson, did you have anything?
Ms. Waters and I were chatting that we feel that it's in the introduction of the policy. Instead of creating additional language and confusing folks, it's right here in the opening 2 paragraphs. And if the language isn't strong enough, then I would suggest, I would be more comfortable adding whatever language that we feel is not there in these 2 paragraphs versus section 2B or 2A.
Yeah, it's funny you say that. My recommendation was going to be that we put whatever it's codified as, where it says state law. and it would be hyperlinked there for people who want to read the statute. But that's just, that's me taking all of your recommendations and saying it says state law.
That would be
So
all encompassing for the entire policy.
I think it's more clear to say it up front than it is to try and explain it in a paragraph later on.
So is that suitable? Does that answer your request, Ms. Caulfield?
Yeah.
Okay. So my question to you is, process-wise, when it's codified, for us to actually have the codification language
Yeah.
in our
and
policy?
We could even, I think it has been codified, or else it.
Okay, so it already has all.
We have a statutory citation, we could, and so the
Sounds
suggestion
good.
was to use the phrase state law, because we don't want, but have a hyperlink.
Does that mean OMB is also codified the budget? Sorry. Couldn't help
No,
myself.
the budget's not. But you would like a hyperlink for, so if you click on state law, it'll take you actually to the relevant portion of SB 49.
Thank you.
I think that would be helpful, thank you.
We got there.
And that is in lieu, I also heard mention of, in lieu of an RMP for this policy, we will include those.
I was not suggesting an RMP be developed. I didn't know if there was going to be one, if that's where some of the discussion would belong. But I'm perfectly happy with, I'm the one that brought up the RMP, so no, I'm not making that suggestion.
I have a general question. As we go through and review all these policies, this is ongoing until January 1st, correct? Is this our only revisions?
This will get you into compliance with SB 49. These requirements are in place now, so I do think there's some urgency with all of these policies on the agenda today, to update your policies pretty quickly, because they are the legal requirements, and your policies aren't illegal. They don't necessarily contradict them, but they're not, they don't reflect the new
They're not
legal
reflected.
requirements.
So to Neil's point, these are the only policies we need to touch to hug SB 49. We will soon know the codification. We'll call it SB 49 for now. So this is all we need to hug SB 49. That's the answer. That's the first answer I'll give you. The second answer is, as we talked about earlier, so we're moving this to first reading, which again, this board has done a great job of reflecting following the first time that this is in committee. And I will ask you the same thing again, that once you reflect on it, and if, when it's coming, which I was gonna say for the end, but if you have changes or thoughts, and you wake up and you have an aha moment, then my ask is that you follow the process that we've been trying to implement, is let staff know, hey, I had another thought. I wanna revisit, section A of policy 4720. And here's my question. Because once we get in the first reading, of course, we will then have a second reading to pass it out. And I'd like for staff to be able to do the research to adequately answer the questions and not have to have Dr. Grant and Attorney Ramey figure it out while we're in committee. So that's my request, is this is not our first opportunity. It is hopefully your first reflection after having read the policies. That's why we will have first reading, then you can have other reflections. But I am asking that, you all know, as a non-teacher, I love to say homework, that we do our homework and let staff know in advance, hey, I have another thought or a change or a recommendation. So if you'll put that in writing to staff so that they can be prepared to address it. And then we'll either pass it out at first reading or not. And of course, when it doesn't come out, when it doesn't pass first reading, it comes back to policy. What I will say is the chair will then convene a process of which, if you ask staff for a change prior to first reading, we can reflectively make that change in board meeting on first reading and still pass it out. So first reading doesn't mean it has to be this. We can make a change at the board table and still pass it out at first reading. Does that make sense? So our process is first reading is what comes after policy. Any changes you have, they can be reflected at the board table and still voted out of first reading at the board table. They don't have to be.
Are you saying that?
I'm saying you can
bring
make
it as
changes.
action and then change it, bring it to consent?
It'll be on action anyway. First reading is on action.
Right.
Typically, what we do is if between first reading and second reading, there are additional changes that we make, we will bring it back on action for the second reading.
For second.
Typically, we do second reading as consent because there are no additional changes. But if there are changes between the first and second reading, we will bring it on action for the second reading to present it again.
And I'm asking so we don't end up in December that we not do it Dr. Crane is asking. I am asking that we do our homework in between so that we can pass it out on first reading, so that we are in compliance with the law at the end of November, because we only have one meeting in December. So I don't want us to be bumped up against not being in compliance. So that's why my request is, if we have changes, that we make those changes at the table for first reading, so that we aren't pushed for a timeline. But again, the board can do whatever it like. That is my request, because it gives staff time to do the research for whatever the change might be.
I have more questions on
Absolutely.
the policy itself, but for the next section in B, it says well-being questionnaire and health screening forms. How do they provide that? And what if they do not sign it for consent? Is this something that is just like the surveys? How does that work with the well-being questionnaire?
I can't tell you much more about this than what's here, because this is pretty much straight out of SB 49. So this is the law. I think it would be helpful if the General Assembly had explained a little bit more about what they had in mind here, but I can't really think of what to do here other than, I mean, again, I think there'll be further work to answer staff questions. I'm already getting questions and working on principal guidance to help steer principals through these and other SB 49 issues. But this does track the law verbatim. We don't have any really wiggle room in terms of honoring the law, so I think it makes sense to get your policy compliant as quickly as possible and then work on the implementation issues on an ongoing basis.
Okay. And then on item number C, other surveys created by third-party surveys. Can you clarify that? Do we have third-party surveys now? Do we have a third party that provides surveys, or?
I think that's the section that has to do more with technology providers and using data for marketing. That's sort of a COPPA related, because that's old language, right, from previous policy.
Yes, but I think
It's brand new.
there was a prior section on survey collection of student data for marketing purposes, but I think the question's about the subsection before that, other surveys created by a third party, which is, I think the purpose here is just, this again tracks SB 49, that even if a survey is not a school district survey, but you're passing it on to your students, we still have to.
So an example I'll give you, that this is not the example they used in the discussion. This is all new, so you're asking staff and they can't interpret what the General Assembly meant, because this is their language, not
So
ours.
this language is from the GA?
All of this in red with no mark out is not ours, it's straight from statute.
Okay.
So the
NCSBA
staff,
language to-
you're,
yeah, to
I want to
track.
clarify, the staff can make up an answer, but they can't interpret what was
Right.
intended here.
Okay.
And there are examples, like Post Center would be an example I'd give you, right? When kids go for the dental checkup, they do like a little kid post survey, did you learn about what plaque is? That would be a third party, but that's not the example they used in discussion of this bill.
Okay.
Does that, and again, that is us interpreting what the General Assembly meant, which is probably never a good idea.
So is it safe to say that most of the red writing that we're looking at, that's underlined, is from SB 49
It is 100%
directly?
accurate.
All
Here
of that
especially.
language comes from the School Board Association and their attorneys, as they are making changes to their model policies, and they recommend, as we are a subscriber to their manual, and we are aligning all of our policies to their manual, these are the revisions that they are recommending to us. We work through them with our attorneys, always before we bring them to you.
Yeah, I do think, it's an interesting question I hadn't really thought about, that's subsection C, other surveys created by the third party. I don't see anything in SB 49 to that effect, but I assume what NCSBA is doing here, this is their recommended change, it makes sense to me, is noting, we may not have all these rules on protected information surveys for third-party surveys, but parents still, at a minimum, ought to be able to inspect any survey before it's
Yeah,
administered.
and there was discussion on what third-party surveys were, so I'm interpreting that's why School Boards Association included it. It was a rich discussion on third-party, what type of organizations could be giving school surveys. So it's a huge
Yeah, I
part
just
of
wasn't
Senate Bill
sure
49.
if we had third party already, and then, I mean, if item C is even necessary, like, does it confuse it to separate the two between it's a third party, or it's Wake County, or it's a school, or it's a teacher survey, or should we just say all surveys to avoid confusion?
So I hear you on confusion, and I guess what I'm saying is I think the School Boards Association is trying to hug the intent, which there is a significant concern about organizations who may be coming in for, I use POST because most of our schools use it, but there are school-based decisions to bring in outside organizations. And this says, as a clear articulation, that you are not to use Monica's LLC survey. So you could say all, but I think, my personal preference is, given the concerns of the General Assembly, I think it should stay standalone as a third party. Dr. Taylor?
So stop for a minute. I think what we can do is collect as much information as we can about third-party surveys, as long as there was a discussion, and then share that with the board so you can be aware of what examples are, and then we can certainly determine if we're using any third-party surveys. So we can get that too, so we can have a better understanding.
Yeah, I appreciate that, thank you.
And we do use them. Mr. Evans?
Thank you. So I just want to be clear, and make sure everyone here at the table is clear. This language was developed to comply with the state law. And there's not necessarily other recommendations or preferences or other ideas, but rather this was what was developed so that we would comply with the state law. Is that correct?
That is the thrust of it, and I believe that's the case in every aspect of this policy, with the possible exception of C, surveys created by a third party, which I don't see a specific reference in SB 49. Everything else is just almost verbatim tracks
Right.
the state law.
And I understand that with the state legislation, they specifically talked about protected topic surveys. They specifically talked about health screenings. And I have questions about that, but if we didn't write it, we don't have the answers for it. And then C is just everything else, because if the law didn't define other surveys, but we know there's other surveys, we should have something that includes that. So I guess the next question I would have would be, do you all have any advice regarding any changes we make or any other directions we go in? Do we then risk no longer being in compliance with state law?
I guess I missed the very tail end of it.
So okay, let me try it this way. You've brought us specific recommendations to bring us into compliance with state law under the new law. And the answer to that was yes. And so then, turning that around, so if we make a bunch of changes to these recommendations, then we may no longer be in compliance
Oh,
with state
absolutely,
law.
yeah.
That's
yeah.
absolutely right.
So we do not have a lot of latitude for amendment or change
Okay.
without an independent examination to find out that anything we want to do is in
I would agree.
compliance.
Any substantive change, we would want to be very careful it's consistent, because
Okay.
this is intended just to get you into compliance with the statute.
Thank you, because I have concerns about a lot of these. I don't understand the language with the health screenings.
Right.
Does this mean we can no longer ask for vaccination records, for example? How far can we say as a matter of practice, we don't want kids to return to school if they still have a temperature. Can we request that information anymore? And it would be great to define those in policy, but if there's no legislative guidance in policy, I don't want to spend time coming up with an alternative if that would take us out of compliance.
Understood. We're looking at the footnote on that third party.
The footnote references the statute on well-being questionnaires. So NCSBA's citation to that provision is the rule that prior to administration, students in grades K through 3, a copy of any student well-being questionnaire or health screening form and the matter for providing consent. So it's not really third party per se, but it makes sense. It makes sense that the student well-being questionnaire, it doesn't matter where it comes from. If it's a student well-being questionnaire, you need affirmative parental consent. So I do think it makes sense.
And then I guess just my last question. I know, again, I'm not advocating any change because I'm concerned that I don't think we can change. Any changes will risk us being out of compliance, but what does Section E mean? Other relevant policies?
That's a reference to the Protection of Pupil Rights Amendment,
Uh-huh.
because this policy started, many years ago to implement federal law, which allowed the opt-out for the protected information surveys. And I guess this is just saying that we we still have to comply with the PPRA in addition to state law. So I guess that could matter, for example, if state law were to change in the future, then you say the General Assembly just repealed this part of SB 49 entirely. We're still back to the PPRA. We just want to have that foothold there.
And that is the origin of Section C. That is straight out of PPRA, the federal statute on protected topics about third-party surveys.
And please forgive my frustration with it. It's just a lot of difficult changes, but then also knowing that we don't have a lot of latitude to come in and make the changes, you know, is what breeds the frustration, not that you all have brought this to us, so thank you.
Whether it's state or federal law, who determines whether we are actually in compliance? And then what is the process if we're not, what's the notification process if we're ever not in compliance, and how would that work?
That's a great question. Federal law, I can tell you, because, and I'll have to look up the state law question because I'm still looking everything up on SB 49. Under federal law, for the Protection of People Rights Amendment, violations can only be, there's no private right of action for a lawsuit or anything. You can file a complaint, the parent can file a complaint with the Department of Education, and the Department of Education would issue a letter of findings, corrective actions. I've never heard of that happening in any school district that we've represented in many years, so I think those are pretty rare. For SB 49, I'll have to look it up because there are different remedies for different parts of the law, so if you give me a minute.
I guess I meant it just broadly, whether it was one state, whether it was SB 49 or something else. That determines compliance at the end of the day.
Well, it's it's both. You have to comply with both, but fortunately, since the same categories apply for protected information, SB 49 is more restrictive than federal law. So basically, state law is all we have to worry about right now. It's the opt-in for protected information surveys. And as far as the remedy for that, I believe this is one of those issues that could be appealed. This is a to-be-developed policy issue that we have to do by January, is come up with a process for parent concerns to be brought to the school board and eventually can be appealed to the State Board of Education. And then even beyond that, parents could file lawsuits for injunctive relief and could recover attorney fees. So if a school district was illegally administering surveys without parent consent, there would be an opportunity to correct internally through an internal grievance process to be developed. If that's not successful, it goes to the state board. If the state board resolution isn't satisfactory, the parent can file this.
So just to repeat back what you said, Wake County would come up with a policy to determine how we remedy that.
I think you can, we don't need to address that yet because that requirement to develop a process for resolving parent concerns under SB 49 has been, the implementation's been delayed. I would imagine NCSBA will tie it into your existing grievance policies and complaint policies in some way, because there's no need to reinvent the wheel when you already have a process for parents to bring challenges ultimately to the board. But we'll see what they develop, and that will come back to you. But that requirement is not in effect yet.
Okay.
We'll have another question.
Okay. Does that answer your question, sir?
Yeah.
Okay. Ms. Kaufman.
So we're talking about this whole policy here is based on an opt-in clause, right? But on item number D, it offers on item number D3, it says the offer the parent the opportunity to opt out. So why would we offer them opt out if they have to opt in? I'm confused by that.
First paragraph, number 3, regarding in the event the board approves a collection, disclosure, or use of personal student information.
It's because this is not an SB 49 issue, I don't believe. This is another law that it does allow you to share information with marketers as long as parents can opt out. Now, I understand you don't currently share information with marketers, so what we could take that out. All the NCSBA language does is allows you to do what the law requires if you so choose. But the current practice is not sharing any information with marketers. I'm quite sure of that. Is that correct? I've seen lots of nods.
Our directory information policy addresses that.
Right. Our form agreements, directory information policy. That's right. We already have lots of protocols in place to prevent that from happening. In fact, form agreements that we've drafted for for staff strictly prohibit the use of any student data for work.
Okay, and then if I can just back up to what Chris was asking about, because that was one of my questions, so thank you for bringing that up. On item number E, for the other policies, is that open-ended? Is there, if we do come up with other policies, will it be added here, or will it be put in another spot? Will it become part of 4720 as another letter, or will it be another policy that is somewhere else with a different number?
It could be, yeah, there is policy 1310. That's one that we have to get updated by January 1st, parental involvement policy. It might be in there. I'm not honestly sure about this. This is an NCSBA edit, so clearly they would not have referenced other policies concerning surveys if they didn't have model policies, other model policies concerning surveys. So I'm sure we'll see those, or Julie and I can ask what they have in mind here. But I'm not, do you think of any offhand, Julie, that we have currently in the policy manual? I'll do a search.
No, I cannot.
I can't either, not off the top of my head, but I'll do a quick search.
Are you looking for it now, Dale? Yes, I think so. Yes,
In their model policy, they include parental involvement, which is one that we're migrating, the parental inspection of and objection to instructional materials, student records, and a policy we do not, have not adopted called advertising in the schools. So they do list some policies. We have not listed those policies before, so they did not list them again when they recommended the revision.
So, off of what Chris was saying before, to keep us in compliance, some of this verbiage is actually from the School Board Association based off of SB 49, right? It's not specifically SB 49, but it's the way that the school board has recommended we word it.
Correct, School Board Association.
Yes, but what they have done, it's not a case where they've said, well, here's how we would suggest you go about complying with the law. They've said, here's how we would state the legal requirement verbatim in your policy. So they're really not colored outside the lines here. They're just giving you language that reflects exactly what the General Assembly is required.
Okay, thank you.
Thank you for the clarification. Any other questions? Does that answer all your questions, Ms. Col, I mean, that particular question, Ms. Col?
Yes, thank you.
Ms. Emmons, then Dr.
I just wanted to circle back to section B, the several minutes ago when we were addressing that, and Ms. Caulfield had the concern about what was in those questionnaires. The second section of B specifically circles back to, you know, if a questionnaire or health screening falls under the definition of a protected topic survey, and it references that all those rules apply. I thought that was an important point to make for anybody listening. And
Dr. Ing?
This is just a comment, really. I think some of the verbiage, in some ways, is really, I mean, it's pro-parents in such that it's really specifying, for example, the third-party issue, that in addition to what may be coming straight from our departments, that the parents can also have the right to inspect things that are not created by us. So I think in some ways it brings up even more, of what the parents are concerned about. So I'm fine with that language.
Which part is that?
C, other surveys.
And on the other side of the receiving as a board, I think it is a protective factor because there have been school boards who've had quite a bit of community back and forth about third-party surveys. I think it's also a good protection for those of us who are all at this board table who could be and receive a lawsuit.
Right. It's like, well, we don't do it.
Exactly. That won't fly. right? We can't say we didn't do it.
Oh, and actually, folks, I just double checked the statutory reference there in the other survey section. That is part of the parents' pupil, protection of pupil rights amendment, the federal law.
That's what I thought.
So it is just restating a legal requirement. In this case, though, it's a pre-existing federal law requirement, not SB 49. That's why I couldn't find it in SB 49.
Thank you.
Thank you. Good question.
Any other hands, feedback, or thoughts about this? Okay. All right, seeing no hands, I'll entertain a motion for moving this one to first reading as well.
So moved.
Second.
Mr. Hagerty was just wanting to make it easy for you today. All in favor, please vote by saying aye.
Aye.
Any opposed, same sign. The motion carries.
Just as far as action from staff, I heard you'd like to see a clean copy of this
Yes.
with all the revisions accepted, and that we are going to add the links in the first sentence. No R&P, but add the links to
Where-
state
the
law
first
where it
state law.
says state law, we'll add a link there, spell out the statute and provide a link there. And that we are going to get some information on what third-party surveys that we are using, if any. Everybody good with that?
Yes, thank you.
Okay, just wanted to double check we have all the right things noted. All right. At this point of the agenda, we're going to shift to, instead of revision, we're going to shift to migration. We are in the 7,000 series policies now. That's a happy thing to be in the 7,000 series.
Yes, it is.
Thank you. In moving to the 7,000 series policies, there's one policy, the first one, 7,300 staff responsibilities, that does have a bit that addresses an SB 49 addition. Staff will point that out. Then we'll move to 7305, which is a partner policy to 7,300. So if we adopt them together, we can in full remove some other ones from our old manual. And then finally, we have an R&P that will be a new R&P for us, so we can fully remove another R&P that's in our manual. So welcome to the table, Kendra Hill and Sally Kowski from HR to walk us through these policies, and I'll take notes for y'all.
Thank you for continuing to be a note taker, Dr. Crane, and welcome to both of you to the table.
Turn this over. You all know. Thanks.
Good afternoon, Madam Chairperson and board members and Dr. Taylor. Thank you all for having us here this afternoon. As Julie mentioned, I'm Kendra Hill. I'm the Senior Director of Employee Relations. Nice to see you all again. And also have Sally Kotowski, who is our Senior Administrator for Compliance, here again as well. And we are ready to speak with you guys with regard to some of our 7,000 policies. As you may know, we are working to begin migrating the 7,000 section of the policy manual, and with these new parental policies, we are able to begin that process. The first, just a little bit of background, Policy 7300 is one of the policies that brought us to you today. That particular policy was on the list of the Parent Bill of Rights policies. Once we saw that policy on there, and it was on that list because of one change, which we'll point out to you, but the board had not yet adopted Policy 7300. So we wanted to make sure to bring that policy forward. And in addition to that, because our original policy that's impacted by Policy 7300 also dealt with conflict of interest issues, we also brought that policy forward so that we could get all of those things cleaned up at one time. And so the policies that we have for you for consideration will be Policy 7300, staff responsibilities and code of ethics, an R&P to Policy 7300 and 5015, which is recruiting of student athletes, and Policy 7305, employee conflict of interest. With those policies, and if we're able to move forward with those policies, then there are several existing policies that, and R&Ps that will presumably come out of the board manual. That will include our current code of ethics, which is policy 2305/3005/4005, as well as RMP 1 and 2 that go with the code of ethics. In addition to that, policies 3242 and 4242, which are unethical influence, will be addressed. Policies 3243 and 4243, gifts to employees, as well as policy 4202, responsibilities and duties. So that's just a quick outline of where we'll be going, and I will begin if I'm able to move forward, Madam Chair.
Yes, sir.
We'll begin with policy 7300, staff responsibilities. With regard to this policy, this is the original policy from the School Boards Association entitled Staff Responsibilities. As we reviewed this policy, it was clear to us that this is where we should incorporate our current Code of Ethics policy. And so, in the very first thing that we did was modify the title to change it to Staff Responsibilities and Code of Ethics. And then the very first paragraph in this policy is the first paragraph from our current policy. And we took that first paragraph. It is a really important paragraph to us. In employee relations, we often cite this paragraph when we are dealing with employee conduct matters and issues of that area. And so we took the language directly and incorporated here for our first paragraph. The rest of the changes, the sections 1 through 4 here, we did not make much modification to number 1 through 4, except that in number 1, we referenced the state board policies, as well as codes of ethics that are applicable to an employee's position. And the reason we referenced the code of ethics is because one of the RMPs for our existing code of ethics and standards of conduct was in fact an RMP to the testing code of ethics. We did not feel like we needed to include that as an RMP, and in fact, in looking at it, I think it's been an RMP for a long time, I think since the 1980s or 90s, where information was not as easily available through a click. And so now we feel like there's enough access to that information that we don't need it as an RMP, but we did want to reference it here in number 1. Numbers 5, 6, and 7 in this section and number 8 and 9 include information from our existing policies to incorporate some of the standards that we already had in our existing policy. And you'll see in the comments on the side, it tells where this information comes from with regard to our current policies. And so performing jobs in a competent and ethical manner, that comes directly from our current policy with regard to our code of ethics and standards of conduct. The prohibition against recruitment of student athletes, we put that in there because right now that is in the R&P to our code of ethics, but we are attempting to recognize that as something that our employees need to comply with. And as you'll see as we move forward, it continues to be an R&P right now that we are recommending to go with this policy. Number 7, refrain from the use of any assets or cash funds or anything belonging to the district. Again, that is something that reflects our current R&P and includes that information in there. Number 8, effectively discharging duties. The note here says that it's from our policy 2402, but it's actually 4202. So I apologize for that mistake. But policy 4202 is a responsibilities and duties policy, and so we added that information in here as well. It's in our classified section of the policy manual, but it talks about complying with directives of the supervisor, those sorts of things. Number 9 on here, we added again another important section that we often deal with in our department, dealing with furnishing information that's requested by the board or superintendent or designee. Number 10 is the same as came from the School Boards Association. And then number 11 is the part that was added to this policy that was originally crafted by the School Boards Association so that it deals with the parent Bill of Rights section. So that's where number 11 is, and that's really what prompted bringing this policy to you. But as I said, we wanted to go ahead and incorporate all of the issues related to this policy. The paragraph following that enumerated list talks about it's not practical or possible to enumerate all situations that might fall under the policy. And that is, again, something that comes from our current Code of Ethics and Standards of Conduct policy. The next section here, we added a header just to make it clear to people that we're kind of breaking into a new section. But this is a section that was outlined by the School Boards Association in their existing policy. The only change that we did here was to include designee with the Assistant Superintendent for Human Resources for reporting criminal behavior, and just ensuring at the very bottom that employees comply with any provision in this policy, and including the section above on self-reporting. That's a broad overview of the policies in this particular, or the areas of this particular policy. If there are any questions, I certainly can stop to take questions related to that.
Okay. First of all, I really enjoy your format.
Thank you. I can't take credit for it myself, but it's the School Boards Association format, but we try to work within that and incorporate our.
But just having the comments on the side.
Oh, okay.
To be able to kind of understand where it's coming from, where it's going, and why, and so that was really helpful.
Wonderful.
So,
I'm making note of that. I wondered if that would be something that was really enjoyed by the board, and that might be something that we can incorporate going forward. I see lots of nodding heads. So I'm making-
Comment box.
You're adding to your workload, Dr. Gray. We appreciate that.
No, it just, yeah, you know.
Although I'm looking at Neil Raby, he's like, this definitely works.
Yeah, we can do comment boxes. That's great. Thanks, Kendra. Appreciate y'all opening the door on that
Absolutely.
for us. We can definitely help with that.
The only thing I would like to add for all of us that can see miles away but not in front of their faces, if the little box on the side could be a little bit bigger.
I completely support you in that. I've had to pull out the reading glasses because, but I'll try to see if I can.
Squinting through my reading
I'll
glasses.
open it in Word and zoom in.
I'm zoomed in, it doesn't matter.
Well, it doesn't matter if you do it from a PDF. It's bigger if you do it from Word. You
Yes.
can make it like 175.
We will see if we
I
can.
just know because I can't see it.
We'll try to
Yes,
find a
like
way
this.
to make
This is
it
what it
bigger.
looks like.
Yes, then you're scurrying all over, but yes.
But I completely agree with you, and we will work on that.
Thank you. It's the little things.
Any other questions with regard to that one? Yes, ma'am.
Yes, ma'am.
Just a quick point of clarification. So under the section for self-reporting requirements for criminal conduct, and it lists those out, is there ever occasion or need to be notified if someone has a restraining order? Does that policy, does that ever occur as an issue?
So generally, we don't require people to report restraining orders as a part of this process because those are not done under a criminal
Right.
order. But there are times where if someone has a spouse or someone else that they don't want coming to the schools, that they will often notify the administration, let them know that that there is a restraining order so that there can be someone looking out for that or any other department as well. So it's not something that's reported to HR, like an employee has to report that to HR. But our employees, from what I have seen in the past, will often notify supervisors, front desk personnel, other people, if there's a concern there.
And it is a part of their safety plan if they're domestic violence survivors, that they give it to their employer, an actual physical copy of it.
And then in turn, if they are the person that the restraining order is filed against, same philosophy there?
So again, normally restraining orders in and of themselves aren't things that are necessarily reported to us. If there is a criminal element attached to that, so sometimes someone might have a criminal charge in addition to the restraining order, then that's something that we would know about, and as we're looking at the criminal charge, we are often made aware of any other order that might be attached to that criminal charge. Yes.
Any other questions? Okay.
Thank you. So the next document I'll ask you to look at is Regulation Code 5015/7300, recruiting of athletes. This information in this RMP was a part of our RMP 2305/3005, and we've essentially picked it up and put it in this RMP, kind of left it by itself, the only piece of RMP left with this particular policy. We did add it as a cross policy to the 5015, which is the volunteer policy, because one of the things that we changed in the RMP from its original language was to make it clear that it wasn't just no employee, but we added volunteer coach or other individual affiliated with the athletic program or school. For your information, we did work with Darren Coe, our Director of Athletics, as we reviewed this RMP to make sure that it reflected the things that are relevant right now for the athletic program. So for example, in number 4, the old language said attending middle school games for the purpose of recruiting student athletes, and that's now been changed to attending athletic contests going across the area. The otherwise, most of this language is exactly the language that was in our original RMP 23005/3005. One other change on the very last paragraph in the policy is to clarify when a student or when school folks are able to talk to a student with regard to athletics, and it talks about the student receiving official final notification from school assignment, and also the date that's set by the school system director of athletics, and then at that point, there can be conversations about athletics with regard to the student. So that is really the main changes there with regard to RMP 5015/7300.
Good. Dr. Amy and Mr. Hershey.
Quick question, does this also pertain to a situation where a student would want to go to a different school or for a different sport? You know what I'm saying? And somebody may be recruiting for the same sport, but what if a student is being recruited for a different sport? Is it still pertaining?
So I'm not the director of athletics, but I would say, yes, it's not specific to, one sport or the other sport. The idea here is that it's not appropriate to recruit students to transfer schools to participate in athletics.
Okay.
Which we often see come up as student assignment, to your point, Doctor. Which is different for HR to hear that, but we often have to sort through that.
Well, I missed your last part. When did you say a coach could start talking to a student when they're in middle school?
So if you look in the last paragraph, once a student receives notification that they've been assigned to a school, and then once there's normally a date that the director of athletics lets folks know, okay, now that can be discussed, athletics can be discussed with the student assigned to your school.
If we have feeder patterns, and we do, why, if a kid is in 7th grade and they are going from Carroll to Sanderson and they're not going anywhere else, are we really saying that a coach can't go and watch or attend a game or talk to that student?
So I'm going to, and I apologize that Mr. Coe is not here, I will defer some of those questions to him for clarification. If the idea is, I believe, there are activities that are going on for all students or something like that, something that's not specific to recruiting. Again, this is about recruiting students for the school. So I think that is, it's clear that if it's generalized things that are done for any students, that's a possibility. But with regard to, hey, we're a feeder school for X location, if that child is not officially assigned, whether it's a feeder school or not, if that child isn't assigned to that school, then there is the concern of recruiting for that school. So it's really hard to know on an individual basis when a child is going to go to the feeder school versus they've applied to go to other locations. And gathering that information of, hey, are you coming to this school? So now I can talk with you. I think until that final determination is made with regard to where the student is going, there are limitations on that.
Okay, so I kind of have a problem with that, because if a kid is at Wake Forest Middle School and their base is Wake Forest High School and that's where they're going, it feels like we are overburdening coaches by saying, you can't go talk to this student because they haven't officially been assigned, even though their brother or their sister went to Wake Forest High School, and I'm using that as the example, but that happens at a bunch of schools. And the reality is that coaches talk to kids all the time, not necessarily, and I wouldn't call that recruiting if you're at a base school and you're following your base path.
So I would say this, we also see students who may have family that have followed a base pattern, but for the individualized needs of that particular student, they may not be looking to go to the base school. And again, I don't know that it's clear that the coach will know that that child is going to that next school until that child is assigned to that school. So I think it's really hard to be certain, because sister and brother went to that school, that kid will also go to that base school. And let me also say, these regulations have been in place, and I think our coaches and other people know and are aware of these regulations. They've been in place for a while, so.
Yeah.
Oh, and I'll let AJ join, because he has.
Go ahead.
I think Mr. Hagerty had a question as well. I'll let him go.
Well, I've got another question, so go ahead, if you got something.
No, y'all go ahead. I'm ready to.
So
You can follow up with it now.
I'll let that go for now. The other question I had and concerned other individuals affiliated with an athletic program. And we kind of say, when we're talking about disciplinary action, what's the disciplinary action for the other? And I would say whether they're affiliated or unaffiliated, because we have plenty of athletic programs that may not be affiliated, AAU or outside, fall ball, whatever. They may not be affiliated directly with a specific athletic program, but they could be trying to influence where a kid goes. And do we have provisions to either ban them from Wake County Public Schools athletic events or something else? It's in the first paragraph.
Thank you, I appreciate that.
We kind of say an employee could get terminated, a volunteer coach could be, could not be allowed to do it, but then we don't have anything for the other individual affiliated, and I would also say unaffiliated. I would add unaffiliated as well.
So let me just say, when we get to policy 7305, there is language in this policy that deals with undue influence unethical influence of students, and I think that may get to some of the questions that you've raised there with regard to that. In terms of what happens to someone who recruits a student improperly, I don't think I can give you that answer without knowing context, issue, what's happened there. So I can't answer that, and I'm sorry, to
That's
fault.
okay. But could we say, if we're saying up to, could we give like the ultimate up to being banned from Wake County Public School sporting events kind of thing? Do
Well-
we need to build that in, or is that included automatically?
I would say it's not a good idea to build that in because the circumstances are going to be so specific to what's going on there. The up to and including termination, again, that's not saying that's what's going to happen with that employee. That's something there with somebody who is, I think what you're talking about is a non-school person who might be involved in these activities.
Well, you said that either the other individual affiliated with, which
With
is.
the athletic program.
Or someone who's unaffiliated. And I want to make sure that we have that whoever is in charge has the ability to make sure they are not allowed to attend Wake County Public School events if they violate this policy.
So as this regulation is written, or this RMP is written, it's dealing with people who are employees, coaches with the school system, or affiliated with that program. So it's not written for unaffiliated people. It's really focusing on those people who are affiliated. I think this policy 7305, as I said, deals with the undue unethical influence related to students, and I think that will get to your unaffiliated folks, or more specifically address those folks.
I'm just going to ask this one last time, but the individual affiliated with, do we have to build in their maximum, what could be, or do we not need to? Or is that off?
I think it's an interesting question. I just looked at both the first two paragraphs. The way I look at it is there can be disciplinary action against a person who is either an employee, a volunteer coach, or otherwise affiliated with the school's athletic program. There's only going to be really two categories of people. They're going to be employees, they're paid, or they're going to be volunteers of some sort. So I think the catch-all other individual affiliated with the athletic program, that's probably for people who are volunteering in some capacity other than as a coach. Right? Because you say an employee, no employee, volunteer coach, or other employees.
Well, there are athletic booster programs that are
Right, so
pretty significant.
exactly. A parent who's volunteering and assisting with Booster Club and is at every athletic event and is affiliated with the program to some extent may be covered. That person would be a volunteer, not an employee, so you can't fire them, right, because you don't employ them, but you could revoke their volunteer assignment. So I think it's meant to capture the maximum penalty. The worst case scenario is you could fire the employee or tell the volunteer your services as a volunteer are no longer needed.
Thank you.
I don't necessarily agree with that way it's written and that interpretation, because that's not saying, if you're with an athletic booster, you're not really signing on as a volunteer through the school necessarily. I don't think that's been my, go ahead.
I was gonna let the lawyers answer it, but
Well, I may have an alternative, which is, I think there's a lot of good questions that Mr. Hershey is bringing up, and I have some similar questions, but they're not necessarily directed to this policy, but maybe go more into the RMP that we haven't talked about yet. Dr. Robinson, I'm putting him on notice back there, he put up this nice board here for a parking lot. And what I'd like to do is request maybe that we could pull that RMP and the discussion of this, because as we talk about improper recruitment, you also reference the assignment policy, for example, and to kind of put some teeth into what we've talked about, I'd like to see further amendment to policy 4150 about transfers and assignments, specifically the section 1C7
staff.
that has to do
You
with
write that down. He's
the
gonna put that on
authority.
the parking lot sticky.
Yes.
Yeah, yeah.
And we're going to put it up there. And so, because I think all of these are related and topical, but we don't have time to talk about them maybe today. Would you like to see
Sure.
like an
Yeah.
expanded conversation? Okay, that would be my suggestion.
I will say, we do have a policy on parent organizations, that's 5010, which includes athletic booster clubs. And the bottom line on that, under the conditions for establishing one, is that upon recommendation by the principal, the superintendent's designee may grant or deny a parent organization. So if there were a lot of undue influence going on and the principal became aware of it, they could recommend to the booster club that you can no longer be affiliated with our school. So there is some way that a principal has a relationship with that booster club under our policy 5010, parent organizations.
Yeah.
So there is that arm of how you might deal with a parent organization or an athletic.
We can chat with it later, we got more stuff to do. Yeah, it's not bad.
I will also add that there is also with our parents, organizations, boosters, those sorts, the vast majority of the time, those people are in fact signed up as volunteers, and they do operate under that volunteer piece. The other thing I would say is that there's also, in addition to the policy that Dr. Crane referenced, there is a policy that I know we will eventually need to migrate as well, which is policy 3620, which deals with these programs as well. So that may be one that you might want to look at that one in conjunction with what is being added to the board as well.
What number was that?
3620.
In the old policy manual.
No, it's one of the
It's a new
new,
one?
one of the
Okay, great.
new to be migrated.
Yeah, it hasn't been migrated yet.
Yeah. And it also deals with these athletic entities. Okay, so we will,
Sorry, Ms. Copeland, you have a question here?
I just have a quick question, and it might just be a quick answer or referring me somewhere else, but this policy is referring to recruiting of athletes between middle and high school, right? Between our schools in Wake County. This has nothing to do with coaches talking or helping students with applying to colleges or anything like that? This is just pertaining to them transferring between our,
so, right, this is related to anyone, it could be internally, but I think also it would apply to a coach going to another district to try to recruit a student to our schools as well. But what, right,
but it's within high school and below.
right,
university.
right.
Okay.
This-
I was just making sure, because it says for athletic purposes, and that's a big thing for high schoolers.
Right.
So I just want to make sure.
If, I will say when you look at, and we'll move, when we move to 7305, there is this unethical influence. I know I've mentioned this several times, but I think that might get to more of those issues that you've just raised with regards to, taking improper actions to.
And they actually do have real consequences for the NCAA.
Yeah.
Very different, that we don't cover.
Yes.
Okay, thank you.
But like for the high school coaches.
I do know, because my husband has to be certified.
Yeah.
Oh, yeah.
So,
Any other questions?
Ms. Evans?
I do. So
They do.
I want to know, Madam Chair, about process with this specific 5015, 7300, and how our process today relates to, because it seems like all of that in the parking lot is connected. So does this have to go to first reading today? Do we have to move it to first reading?
We don't have to move it to first reading, and also,
This is RNP.
yeah, this is, you read my mind, I was like, and this is RP.
Item, for you guys.
Yeah,
So,
not policy.
I mean, obviously, we want to know the thoughts and recommendations. This is, RMP is how staff puts things into action, and policy is your policy.
Right.
So we brought this as an information item.
And
I
the
see,
follow-up
I see.
to that is,
Thank you.
many of these are policy changes.
Right.
That our policies are linked. So once we migrate the policy that we're talking about changing, it retroacts the change to the policy that it's footnoted, which is why boards go back and forth if they like footnoting other policies. But this is the RP.
Thank you.
For what it's worth, I was thinking about Mr. Hershey's request for a change here, and there is an pretty easy edit. If you all feel like there's a gap, because we do have 3 categories in the beginning of the policy: employee, volunteer, coach, other individuals affiliated with the program. If you want to replicate the 3 categories in terms of potential penalties, one very easy fix there would be individuals who violate this policy will be subject to disciplinary or other appropriate action up to and including termination of employment, revocation of volunteer assignment, or revocation of affiliation with the athletic program. And that would sort of mirror the 3 categories. I'll just throw that out there as a potential RNP revision. Does that address your concern there?
It starts, so yeah, I think that's a good add.
Okay.
I just want to make sure we give principals or whomever the backing of the board, if someone is so egregious that they just need to go.
Right.
And not be on Wake County
Someone
Public
who's
School
arguably
program.
not an employee or a volunteer,
Right.
maybe in some or would have an argument that they're neither, we would still want the district to be able to take some action.
Yes.
I'd say revoking their affiliation. You're no longer, you can't say that you have any connection to the football team.
I mean, Neil, is there any thought to just saying trespass from Lake County?
But that was raised, I mean, I think we do need to be careful about that because there's kind of banning someone from property, especially if they're a parent who might have some arguable claim that they have a right to be there.
Yeah, it's like, yeah, that's a
Participating in their
lawsuit.
child's, especially in SB 49, post SB 49 era, where you have to be very careful about banning parents from participating in school. But that could be an option, but I don't know that we have to specifically note it.
Because I think Mr. Hershey's point too is some of these folks may not be affiliated at all, and they've taken it upon themselves to do some of this. And so, how do we kind of account for that? But I think if this doesn't limit actions we can take.
Oh, okay, to that point, yes, this regulation is restricted to people who are affiliated with the athletic program. It's meant to govern your staff, your volunteers, the people that are closely connected. But that doesn't mean you can't take action if you have an interloper who's coming and wearing the banner and pretending to be the assistant coach.
Right.
That person can be told to leave, and that person can be no trespass, absolutely.
Okay. That's what I want. Thank you.
A letter of disassociation.
Yes. I would accept that as the change that
Okay,
you said.
so we'll incorporate that change to the RMP, and then recognizing that you all may be looking at more information related to this in the future when you take things out of the parking lot. Okay, all right, thank you all very much, very helpful information and discussion. The next policy that we're looking at is policy, what we are calling policy 7305, which is employee conflict of interest. This policy was originally coded as policy 7730, but because of the way our policies have been organized in the past and for ease of access for our employees, we are recommending that it be modified to policy 7305 so that when our employees pull up the policy manual, they see staff responsibilities, they see conflict of interest, it's all there together where they would expect to see those two topics rather than further down the page. So with regard to the employee conflict of interest policy, we have kept the language that comes from the School Boards Association in the beginning and through much of Part A here, contracts with the board. One of the changes that we made was in number 3. We added a vendor so that it would be a prohibition when an employee was attempting to influence someone involved in making or administering a contract, when the employee will obtain a benefit from the contract itself or from the vendor related to that. And that tracked our old RMP 2305.1 subsection C, which talked about merchants and others involved in contracts. Number 4 here, we added language in to track our old RMP 2305.1 section D, dealing with soliciting or accepting gifts, favors, rewards, service, gratuity, or other compensation. Again, language that comes directly from the old RMP. Number 5 is an area that comes directly from our old RMP, which deals with soliciting or selling or having a pecuniary interest in supplying goods or services. It allows an employee, it has an exception for employees being able to provide goods or services to the school system if they've complied with the rest of the requirements of this policy, and then if it is awarded to that employee through a competitive process, any such contract to supply would be approved by the Assistant Superintendent for Human Resources in consultation with legal counsel and ensuring that federal and state laws are being followed, and it would not interfere with an employee's ability to do their current job. So again, that's something that's already in our current RMP. And then the next modification here makes reference to our existing board policies dealing with authorization through policy 6420, contracts with the board, or policy 6450, purchase of services. And it just explains that a contract with the board includes contracts with the superintendent or designee as well. The policy then provides definitions within the language. And then we added a section here to incorporate some language from our nepotism section of our old RMP 2305.2, saying that even where an employee will not derive a direct benefit from a contract, they cannot recommend for approval or approve any contract where an immediate family member will derive a direct benefit without disclosure to an approval of the superintendent or designee. So again, that's incorporating existing language that we have. The next section here, misuse of information, we did not make any modifications to this as coming from the School Boards Association. Section C dealt with non-school employment, which is something that we had in our existing RMP. We added to this our non-school activity for compensation, looking at situations where someone might not be employed by an entity or considered an employee, but may still have other activities where they're receiving compensation. And so the modification in section C is the second sentence saying any such employee shall not engage in any non-school employment, non-school activity for compensation, or private business that does any of the following. And then it tracks some of the language, most of the language coming from the School Boards Association, just making that consistent with our current RMP. Number 4 in this section C references our existing tutoring policy that we changed recently, as well as the community use policy, so that if someone is not able to use school system property or equipment or material unless it is otherwise permitted by the tutoring or the community's use policies, or prior approval is provided by the superintendent or designee. And then on number 5, because we incorporated private business into the overall policy here in this section, we just indicated that employees could not do these sorts of activities during assigned work hours. The next section here just includes superintendent or designee granting approval for some exceptions here, and talks about the superintendent would comply with this information and any state laws unless it's set out otherwise within the superintendent's contract. Section D here deals with unethical influence of students, and I do think this gets to some of the issues that we discussed earlier with regard to employees not involved in receiving fees to recruit students for educational institutions, recruiting them to participate in private businesses, causing them to feel like they have to participate in activities that require more than a nominal cost, receiving fees to recruit students, or violating the rules about recruitment of student athletes. The next section, we forgot to label section E, so that would be a change that we would need to make here, is to make that section E. But receipt of gifts, the first sentence in this section talks about no employee may accept any cash gift. That comes directly from our old policy, 3243 and 4243. And then the School Boards Association language, which includes not soliciting gifts for anyone participating in E-rate, and then not soliciting or accepting trips, gifts, meals, other items for an entity that is engaged in business with the school system, except for gifts of nominal value, $50 or less, and which are advertising items, honorariums provided for participating in a meeting, meals served at a banquet, or items that are approved by the superintendent. And again, this would not apply to employees involved in our purchasing, except as provided within the purchasing policies. And then finally, there's a section here added to come from our other policies, which talks about, in other instances, employees shall not accept any individual gift related to their employment, except gifts of nominal value of $50 or less, and even when it's appropriate to accept a gift, that employees should take care that it doesn't create an appearance of impropriety. And this would exclude things like banquets or door prizes, items awarded by the school system. And really, this section is to recognize that we do know there are some employees who receive gifts, or our teachers often, based upon the work that they do, and we know it's important for our teachers to be able to have access to this, but we also want to think about equity issues and making sure that there are not situations where students may feel, or parents may feel like, there is a preference given for people who are able to give big gifts, or preferences provided, when a parent is given a gift to to a teacher on behalf of their student. So we wanted to put some sort of parameters around what that looks like, to remove that sort of notion of impropriety or preferences here. And then the last section here is just about, which would be the section F, is about violations and what happens with regard to violations to the policy.
Thank you. I have some concerns about the receipt of gifts section. And again, I understand why we have it. We don't want to have any actual or perception that anyone is getting influenced by a monetary gift. But I just think when we craft language like this, we really deny a lot of our teachers and staff real opportunities that, again, we know that we do not have the highest compensated employees in this area, especially compared to the private sector. I know that some awards we give, some gifts we give, would be allowed under the last line of the last paragraph, drawings, door prizes, and other items awarded by the school system to employee are not subject to this provision. So I was thinking of our Teacher of the Year. There are several gifts that are provided to the Teachers of the Year. Some of these are provided by people that do business with the school system, right? But because those are going through the school system and the school system awards it, those would seem to be permitted.
Right.
But I know that, for example, we also have our instructional assistant, our teaching assistant of the year, but that is not awarded by the school system. That's provided by their professional association. And so those are staff that are receiving gifts, that I think this policy might shut down. Similarly, we might have other teachers that are receiving awards, mini grants from other professional associations that might be related to their employment, but that might, I don't know if intentionally or unintentionally, could be prohibited by this. And again, I just wonder too, what about gifts from PTAs? If the PTAs do come together, I know there's an equity gift, there's an equity angle, but, does this prohibit a PTA from a gift over $50 made to a teacher, to a staff member, to, a group of employees? Sometimes we have, through GoFundMe or others, you may have non-certified staff who might need money for a family tragedy or a medical situation, or there's been a fire and people in the community come together and give gifts. And I just really worry that language this inclusive without any provision for an exception, might really be too restrictive. And so I don't know, I don't really have a solution other than maybe if you had an exception could be granted, by a supervisor or by some administrative authority, if there was some way you could appeal that. But I know I understand what you're trying to do, but I just see too many gifts of goodwill gifts that I don't want to end by policy.
So I think you're referencing this last paragraph here, is that correct?
Yes.
Okay.
I think the other paragraphs within that seem to generally cover very specific situations that are well covered. I'm not worried so much about, someone in purchasing being denied a gift from a vendor, because you can see the direct line between the gift and their power to make a decision. But I just see too many situations where staff, where staff could receive a gift that could be an important gift, that I don't see any corruption, I don't see any unethical behavior in it, and I just don't want to end that.
To piggyback on that very specifically, I know that my son's teacher in the past had lost a parent, and there was a collection, and there was something given, it wasn't cash given, but it was a gift, flowers, whatever else. Nobody's thinking anything negative in that moment, and parents certainly aren't going to know any better. I fully support what Mr. Agnew is saying.
I third what you said.
So I will say, the policy talks about any individual gift. So the example of folks coming together to do a flower or collection of a gift on behalf of someone would not be considered an individual gift. So I'll say that as to at least that just one example. I do understand and think it's important about the associations and those sorts of entities that are affiliated with the school system, but not necessarily the school system providing those sorts of gifts as well.
Yeah. So we probably had the most robust discussion on this particular paragraph, because like we did not want to limit, folks being able to show appreciation and our teachers being able to receive that appreciation. So the word individual certainly, included to try to account for that. But I also hear the associations, I hear grants. So I wondered if we could take that back and just try to think of some revisions that, or maybe it is an exception clause like Ms. Peggy is suggesting to make sure that we aren't limiting, because certainly our intention was not to, the Wayne County Teacher Association banquet that we all go to limit that. That's not the intention of this policy. So I think maybe we propose some revisions based on the feedback that we're hearing.
Thank you.
Okay, so we won't move this one. I'll let you all take this one back and bring it back to us.
We can't, either we can,
We
or
can-
we can use 49 language. This policy does not, correct? You just brought it along with 7,300.
They
that
did.
are
We
brought it
related.
along with
So
it.
we could pause this
That's
one.
why-
We
that's
should
what I was
move the other
hoping.
one along. because
Yes, that's exactly why. So I was like, this isn't one we need to pass out, so you can bring this one back to us.
Thank you, Madam Chair.
I also wanted to add that this is a concern for me as well, because especially when you're in elementary school, even middle school as well, we're supplying like necessary tools for our teachers in there that actually are for our children. So it's not necessarily like if we're giving a Target gift card or you give them money. And I understand that if it's like a group, it's different from being from an individual, but sometimes when you go to make those collections, there are parents who want to be a little bit more personal with how they don't want to give the dollar store things, and they're able to either through, their company or just directly be able to give them like Costco size or something like that they want to go and do that. And this does kind of limit them to be able to do those things for them. So maybe if it was more in the word of, and I don't know if this is something that would solve that, but more of a donation than a gift, if it's something that they would be not so limited with.
I'll let you all play with it. This one we're moving out, so you all can
Yeah.
play with the language and bring it
But
back.
that too, this is gifts to the employee, not to the classroom.
Well, is the teacher an employee? Yeah? Well, that's what I'm saying.
I think we could look at language around the clause that
We're not
says
gonna circle the wagon on
classroom
this.
donations do
It's
not
not
apply to
necessary.
this policy or
That's correct.
something. Yeah.
Yeah.
I'll trust that
Sometimes
won't
you
bring
can
it
give
back.
like a, even a massage, gift certificate with the supplies and just like a general basket, and, nobody's getting a massage for $50. If you do, please let me know where. But I'm saying something like that is for the teacher,
Yeah,
but
yeah, yeah.
it's basically for, how much they go through and everything, so it's added with supplies, and it does really limit.
We'll let you discuss this when they bring it back.
Thank you all for that feedback, really great.
And we appreciate you, Dr. Matillo and Ms. Hill, for saying, yes, we will bring that back. All right, Julie, what do we need to move out? And clearly, we're not getting to the last one.
To my knowledge, there was not a vote to move 7,300 for first reading, so we do need a vote on that.
Yes.
So moved. Madam Chair.
Mr. Swanson, 7,300, Mr. Swanson, Mr. Henry. All in favor, please vote by saying aye.
Aye.
Any opposed, same sign. The motion carries.
We are bringing back 7305 conflict of interest with the revision to that second part. And the last bit